The privacy and data protection laws in the United States are characterized by a complex patchwork system that spans across both federal and state jurisdictions. Unlike many other countries, the US does not have a singular, overarching federal privacy law. Instead, it utilizes a combination of several sector-specific laws at the federal level, alongside a myriad of state laws that can sometimes overlap or even exceed the requirements of federal regulations. Federal privacy laws. At the federal level, the United States relies on a sectoral approach to privacy regulation. This means that specific industries have their own tailored privacy and data protection laws. For example, 1. The Health Insurance Portability and Accountability Act, HIPAA, governs the privacy and security of health information. 2. The Gramm-Leach-Bliley Act, GLBA, sets requirements for financial institutions in handling customers' personal financial information. 3. The Children's Online Privacy Protection Act, COPPA, regulates online services and websites that collect information from children under 13. 4. The Federal Trade Commission Act, FTC Act, empowers the Federal Trade Commission to act against deceptive and unfair trade practices, including violations of consumer privacy. These federal laws are complemented by rules targeting specific practices like telemarketing, email marketing, and online behavioral advertising, among others. The Federal Trade Commission, FTC, plays a central role in enforcing privacy laws and has been instrumental in shaping the privacy landscape through its enforcement actions. State privacy laws. State-level privacy laws introduce another layer of complexity. States can enact laws that overlap with or extend beyond federal regulations. This results in a mosaic of privacy obligations that businesses must navigate. For instance, 1. Data breach notification laws. All 50 states, the District of Columbia, Guam, Puerto Rico, and the Virgin Islands have enacted legislation requiring private or governmental entities to notify individuals of security breaches involving personally identifiable information. 2. Biometric information privacy. States like Illinois, Texas, and California have laws regulating the collection, use, and safeguarding of biometric information, e.g., fingerprints, voice prints, and facial recognition data. California's privacy legislation. California has been particularly proactive in privacy regulation, exemplified by the California Consumer Privacy Act, CCPA, and its successor, the California Privacy Rights Act, CPRA. The CCPA, effective from January 1, 2020, was a landmark law that granted Californians the right to know about the personal information businesses collect about them, the purpose of its collection, and the entities with which it is shared. It also allowed consumers to opt out of the sale of their personal information and provided for the deletion of their data upon request. The CPRA, approved by voters in November 2020, expanded these rights and introduced new concepts such as sensitive personal information, significantly affecting how businesses manage consumer data. It also established the California Privacy Protection Agency, CPPA, tasked with implementing and enforcing the law. The enforcement of the CPRA amendments to the CCPA, which began on July 1, 2023, marked a significant milestone. However, a court ruling pushed the enforcement of amended regulations until March 29, 2024. This was based on the legal requirement to give businesses a 12-month window between finalizing any CCPA regulation and beginning its enforcement. This ruling underscores the ongoing evolution and dynamic nature of privacy regulation in the US, highlighting the challenges businesses face in staying compliant amidst shifting legal landscapes. This multifaceted approach to privacy and data protection in the US necessitates that businesses, especially those operating across state lines or in multiple sectors, maintain a vigilant compliance posture. They must stay abreast of both federal and state regulatory developments to ensure they meet all applicable privacy and data protection obligations.